This is another advanced estate planning video. Those seem to be among the most popular on my channel. Hi, welcome. This is another advanced estate planning video. Those seem to be among the most popular on my channels. This one is going to be really helpful if you're the surviving spouse, if you've recently lost a spouse and you're trying to decide what to do next, especially for a larger estate. So this is going to make sense for estates that are over 2 exemptions. So currently that means estates that are over 25 million. So let me share my screen here. We're going to talk about a couple of different scenarios. All right, so let's go over some basic topics. Annual exclusion, this works with the gift tax. So if a person makes a gift of $10,000 and the annual exclusion is $16,000, there's no gift tax return that needs to be reported. The exemption against the death tax is currently, well, in 2021, it was 11.7 million. So it's 10 million adjusted for inflation. So if a person makes a gift of $1,016,000, what happens is 16,000 is annual exclusion, but a gift tax return needs to be filed for the rest, and 1 million will be subtracted from their exemption. So this example, if they used 1 million during their life, they would have a remaining 10.7 million left in 2021. All right, so if the estate is $18 million, and there is only 6 million of exemption. So currently, the current estate tax exemption is set to sunset in 2025. So the exemption then will be around $6 million. So what that would look like. So the tax table currently, the first million is $345,800, and then it's 40% for everything above that. So at 18 million with the $6 million exemption, there's the first million, 345, and then that would be $11 million at 40%, which is 4.4 million, making a total just under 5 million, 4.745 would be the estate tax bill in this scenario. All right, disclaimer trust. So many people have trusts like this. Husband and wife created the trust during their lifetime. They managed it. It was revocable while they're both alive. Then when one person passes away, this disclaimer trust, the way it works is they have the option to give half of the assets over to a B trust. So the A trust, or the surviving spouse's half, is fully revocable. By default, if they do nothing, everything stays in that A trust. Surviving spouse is both the trustee and the beneficiary of that A trust. Now, when they pass away, on the second death, the exemption for the surviving spouse will be used, whatever the exemption is at that time. So currently, 2025, it's set to sunset. To do a disclaimer, you have 9 months from the death to do a disclaimer to create this B trust. This is with trusts that already have this written in. This was kind of a common thing back when we didn't know where the estate tax was going to go or if it was going to be repealed. So the B trust will name a trustee. A lot of times it's the surviving spouse that's the trustee. Let me back up. So you do a disclaimer. It is taxable. So the amount you're sending to this B trust is taxable, but we use the exemption of the first deceased spouse to fund this trust. So although it's taxable, there's no estate taxes that are actually paid. It's irrevocable or irrevocable, if you want to get technical. Surviving spouse is a trustee and the beneficiary. Now, the proceeds from this B trust, so on the death of the second spouse, everything that comes out of the B trust, it's not going to be subject to the estate tax. So if 11.7 million goes in there and it grows to 30 million or 50 million, during the life of the surviving spouse, it's not going to be subject to the estate tax. However, these assets do not get another step up in basis. So if you had a trust like this and a $30 million estate and you did nothing and the estate tax reset to 6 million, here's what that would look like. So the tax bill would be pretty big. It'd be about 9.5 million. if he had a $30 million estate and did nothing. So one option would be to do a disclaimer. So if you do the disclaimer, that's going to save quite a bit. So by using the disclaimer, that allows you to use the first deceased spouse exemption against the death tax, and it's going to save about $5 million in estate taxes on the same $30 million estate. In order to use the disclaimer, that requires a timely disclaimer, timely meaning 9 months from the date of death. Also, you have to be careful that you're not exercising control over those assets during those 9 months. Another option to use the first deceased spouse's exemption is called portability. The way that works is you file an estate tax return, and then the surviving spouse has this exemption to use upon her death. They have the exemption to use the first deceased spouse, so the husband's exemption, and then she has her exemption, whatever that is, upon her death. So what that would look like, it'd be similar to the disclaimer if you did portability. Portability requires a timely estate tax return, which is also a 9-month deadline. However, you can file for an extension and get a 6-month extension. So portability is about the same. Portability versus the disclaimer in the scenario would be about the same estate tax treatment. The existing trust, a lot of times, does not have dynasty trust planning. So this family, the way their plan works is the brother had the right to live in one of the houses, and then everything else went to the daughter or the sister. So brother has some special needs, so that's why a bulk of the estate was going to the sister. But what I don't like about the scenario is there's not a lot of protection for brother or sister with this. So for sister, all of her share going out right to her puts her at risk for future lawsuits. Once you have assets, you become more of a target. So any type of car accident, anything like that, and they discover that you have assets, lawsuits may be more likely. Attorneys are always looking at the likelihood for recovery if they're successful. So assets in your name put you more of a target for lawsuits. Also, the bad thing about this is it's subject to the estate tax again when that child dies. So when things go down to the grandkids, they're going to get hit with another layer of estate tax. So a better way to go would be with the Dynasty trust. The future proceeds are going to be free of estate tax. It's going to go to grandkids free of estate tax. Whatever it grows to, no estate tax again once it's in that Dynasty trust. So the Dynasty trust, you can choose who the trustee is. A lot of times the way I do it, I let the child be the trustee at a certain age. The distributions from the trust are the trustee discretion. They have this power of appointment to choose the beneficiaries. Sometimes I call that the power of disappointment. So if the kids are little brats, you can disinherit them, send everything to charity or somewhere else. And the main thing about this is it's outside of the estate of the kids. So that means it's going to pass estate tax-free. And it also gives them good asset protection because they don't actually own the assets, but they have full control over them. So really the best of both worlds. So assets inside the Dynasty trust, they can be reinvested. They can buy more property. You can create LLCs and business entities to own those properties and assets. If you accumulate assets in your name individually, so subject to risk for lawsuits, and they're also subject to the estate tax again. My recommendations would be to add a special needs trust for brother with autism and special needs, brother receiving benefits, so that way he doesn't lose his benefits. And we can put other assets in here besides just a house. And then for sister, a Dynasty trust would be a much better way to go. Gives her full control, and it saves the future generations, grandkids and great-grandkids, from having to pay estate tax on these assets. Trust decanting, here's the legalities of it in California. That's the probate code that makes it legal. And Arizona's had it for longer than California. It became a thing in California in 2018, and a few years before that in California. And attorneys were doing it long before there were laws in New York. So this is a good way to update trust or fix trust when there's problems. So that's where I practice law, Arizona and California. If you're in a situation where you're trying to decide what to do after the loss of the first spouse, you can reach out to me, reach out to danalegalhelp.com, set up a meeting. We can do a Zoom meeting or we can meet in person. Good luck. Hope you found this helpful.